Mhm. I emailed a lot of attorneys. Yeah. Now, overall instructions, 3 hours. In fact, I found out that a lot of those that are in law school, yes, they should aspire to donating some time to pro bono. Yeah, yeah. Now, I was kind of just reading through some of these questions in the actual syllabus. Yes. A prosecutor learns that Rosh's defense attorney plans to call Frank Williams as a witness. Witness Williams will testify about the deceased William Jones man's reputation for untruthfulness. The prosecutor has decided not to object to this testimony. Instead, the prosecutor plans to respond by calling his own character witness. The prosecutor's character witness will testify that, in his opinion, defendant Rosh is a violent man. Rosh's attorney objects to his testimony. Now, a judge who has to determine whether to allow the prosecutor to elicit this testimony pursuant to the federal rules of evidence will be required to consider whether, if the testifying witness is qualified to give such testimony pursuant to the federal rules of evidence. Yeah. I know. Let's call a witness to the stand. You would testify under oath that I was in Sequim, Washington on December 31st of 2015. When I have the evidence from the bus surveillance camera footage, yes, an email sent from this library that I was not in Sequim, Washington. Now, when do you get to call the witness? After you present the evidence accusing the individual or before? Yeah, yeah, yeah. Now, you could call 100 witnesses that would all say I was there. Yes. But I could go to Clallam Transit and I could produce a fucking video right now. I don't think the federal rules of evidence allow for the prosecutor to call anyone to the stand. Yes. When you have the evidence that I was on the bus that morning and there was no possible way that I was in Sequim, Washington at 7:47 a.m. You can't call a witness. Now, basic evidence. Uh, Appendix United States versus Foster Douglas. Let's look at it. I sent you emails that I had made on June 16th of 2017. Yes. Where I was sitting in front of the Masonic Temple that whole morning. Yes. I was at the Senior Center that afternoon. Mhm. And who were you going to call to the witness stand alleging that I had committed cyber stalking and violating the restraint provisions of the protection order? Yes. Carol Kirk. Am I the individual that you had seen? Yes. Trish Batard as superintendent of the Brennan School District, or the petitioner that didn't sign the forged protection order. Now, I would say that the first rule, yes, is you have to be able to prove the person was there. And when I asked you to acquit me of everything, yes, as in exonerate me, yes, and give me my sons, you said, no, we are going to do a he said, she said. Ouch. But there seems to be a furtherance of the fraud. Yes, there is. Of refusing to acknowledge the laws of the United States. See, the second best evidence was making videos that were uploaded at a certain time, yes, and were recorded at another time, so that I can place myself at making the videos and then uploading them, and then the emails that I sent that day on June 16th of 2017 to approximately 2,000 email addresses. Now, there's a lot of case law in here. And I'm thinking that a lot of this could be useful to myself when suing, yes, those that are police officers. Excuse me, Sheriff. There's a lot of case law in the syllabi. And I think that there should be something that's useful to myself, yes, when suing you. Yeah. Now, as much as you don't want to enforce these rights, yes, you've lost the privilege of being a sheriff. Law enforcement privilege. Yes. Now, evidence offered to show conduct conform to, same rule 406. Subsequent remedial measures. Yes. Offers to compromise, offer to pay medical expenses, pleas of guilty or nolo contender. Liability insurance. Yes. Examination of witnesses. Yes. Can there be any examination of any witness? Yes. When you have the evidence, I wasn't there. Now, what about this oath, Rule 603? Oh, there is expert opinions. Yes. Mhm. Rules of the expert, ultimate issue, disclosure of facts underlying an expert's opinion. Yeah. Impeachment, collateral versus non-collateral matters. Yes. Impeaching my own witness. Yes. Prior convictions, prior bad acts, prior inconsistent statements, contract with. Ooh, authentication. Best evidence, original writing rules. Yes. Now look with federal cases, Seiler versus Lucasfilms. I like this best evidence. See, I thought that up. I thought the first best evidence, yes, was being on the bus. Yeah, it does. And I thought the second best evidence was making a video of my place and time. Yes. And emailing it to law enforcement. But you said no.